I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. The 11th Circuit Court of Appeals has denied Lindsey Graham's attempt to try to not testify before the special grand jury in Fulton County investigating criminal interference with the 2020 election. Lindsey Graham has asserted that the speech and debate clause of the United States Constitution would preclude him from having to testify before the Fulton County District Attorney Fani Willis's impaneled special grand jury. He argued that after the November 2020 elections, his communications was just a fact-finding mission as a South Carolina senator just looking to determine what was taking place there, whereas Brad Raffensperger had previously told the special grand jury in testimony that Lindsey Graham was trying to pressure and essentially extort him into counting votes that shouldn't be counted and to arbitrarily and falsely declare Donald Trump to be the winner of Georgia when the votes simply didn't add up for that to be the case, which would clearly not be what a senator is supposed to do. Nonetheless, Lindsey Graham said all my conduct was legislative in nature. So Lindsey Graham previously tried to file a lawsuit, or did file a lawsuit in federal court. The district court in Georgia initially denied his request not to testify. Lindsey Graham then appealed that to the 11th Circuit. The 11th Circuit then requested that the district court do a more thorough analysis regarding what potentially could and couldn't be grounds for the speech and debate clause privilege. The district court then did that analysis and said, look, it may be the case, Lindsey Graham, with certain conduct that it was investigative in nature, even if it wasn't a formal committee investigation. This district court judge in Georgia said if it was investigative and for your legislative activity, that would be subject to the speech and debate clause. However, efforts by you to try to pressure, exhort, cajole the state secretary of state, Brad Raffensperger, into changing vote counts, that's not investigative in nature. So regarding these other categories, Fani Willis is entitled to call you before the grand jury, and you have to answer those questions. And by the way, if you want to claim they're still subject to a speech and debate clause, which that type of conduct would not be subject to, that's not what the speech and debate clause was meant to protect, you can object and come back to court, and we can rule on each and every one of the questions. But as it relates to you trying to cajole and exhort, or trying to pressure, or you trying to threaten state officials to overturn their election, that is not legislative in function. And regarding your conversations with the Trump presidential campaign, not legislative in function, and you will need to have to testify on those topics. Lindsey Graham appealed that to the 11th Circuit, and in a per curiam opinion, meaning all three judges agreed, they denied Lindsey Graham's appeal. They denied Lindsey Graham's emergency relief to stay or stop the district court's order, and they found Lindsey Graham was not likely to succeed on the merits. And let's just go over this order briefly so you understand what's at issue here. The 11th Circuit, Judge Wilson, Newsom, and Grant, circuit court judges by the court, talk about this emergency motion by Senator Lindsey Graham to stay the district court's order to not go before the special grand jury proceedings in Fulton County. The court goes on to say the speech and debate clause ensures that for any speech or debate in either house, members of Congress shall not be questioned in any other place. They cite the United States Constitution, Article 1, Section 6, Clause 1, and then they go on to say the Supreme Court has interpreted that clause to protect against inquiry into acts that occur in the regular course of the legislative process and into the motivation for those acts. And the clause protects the integrity of the legislative process by ensuring the independence of individual legislators. Now, the court goes on to say not everything a member of Congress may regularly do is legislative acts within the protection of the speech and debate clause. And then it says it's not to be extended really beyond the legislative sphere. And the fact that senators generally perform certain acts in their official capacities as senators does not make all acts legislative in nature. It goes on to cite a Supreme Court case called Gravel versus the United States, where the Supreme Court warned, this is a 1972 case, that it's not sound or wise to extend the privilege beyond its intended scope, its literal language, and its history to include all things in any way related to the legislative process. And so it has to relate to the legislative process, but activities that fall outside of the clause's scope include, for example, cajoling executive officials and delivering speeches outside of Congress. And then it goes into how you determine whether it took place. And obviously, if it was done pursuant to an actual committee assignment, if it took place literally in a congressional session, those are obviously protected by the speech and debate clause. But then there are other examples if it's taking place outside, if these are statements to the press, if these are statements done in a personal capacity, or if these are statements that are done to cajole, to exhort, to pressure people to do illegal things. That's not supposed to be subject to the speech and debate clause. And so the court here then analyzed the facts. And by the way, what the court said is, we're not even sure because it hasn't been addressed yet. Lindsey Graham is saying that he engaged in informal fact-finding. The 11th Circuit actually said the district court judge actually went a little further than maybe the district court judge had to go by saying that Lindsey Graham's informal fact-finding was subject to the speech and debate clause because the Supreme Court hasn't ruled. Can any member of Congress or Senate just deputize themselves and say, oh, this is an informal fact-finding mission? But in any event, what the 11th Circuit said is that clearly the other conduct outside of the legislative informal fact-finding would not be subject to the speech and debate clause. And the 11th Circuit was very complimentary of the process that was established by the district court judge to rule on any, if there are any disputes over questions by Fani Willis, the district court can make those rulings. Lindsey Graham can still object. But what the court found here was that the categories at issue that were established by the district court, which are clearly outside of the speech and debate clause, those are the types of questions that he should be entitled to be asked. They said here, the court also reasoned that the three topics unrelated to the phone calls, communications and coordination with the Trump campaign regarding its post-election efforts in Georgia, public statements regarding the 2020 election, and efforts to cajole or exhort Georgia's election officials were not legislative activities. The 11th Circuit agrees that those are not legislative activities, and they've given Fani Willis the green light to go and ask Lindsey Graham about those three categories. So in sum, a very bad day in court for Lindsey Graham, a very good day in court for justice. And again, this is from the 11th Circuit. Recall in the Trump Mar-a-Lago search warrant case where Judge Eileen Cannon made those horrible rulings preventing the Department of Justice from engaging in their own criminal investigation. The 11th Circuit made the ruling granting the Department of Justice's motion for partial stay and returning the 100 classified records. The 11th Circuit's reputation is that it is a more right-wing leaning court, but what we're seeing is that they are actually upholding law and order. This is not a partisan issue right here. With issues like accountability, issues relating to the accountability for the insurrection, our judicial system is sending a very strong message. They're sending a strong message with this order, regarding Lindsey Graham. They're sending a strong message with respect to Donald Trump's attempts to steal top secret sensitive information. They sent very strong messages rejecting Trump's 70 frivolous lawsuits. Our judiciary is holding strong. And while there's so many rulings that are taking place, which I vehemently disagree with, on this issue of basic constitutional principles, we have the courts of appeals and even the Supreme Court not buying what the MAGA extremists are selling when it comes to trying to avoid accountability for January 6th. Lindsey Graham will testify before Fani Willis's special grand jury proceedings. Now, when will this take place? Well, there is a temporary period, a quiet period, where no witnesses are being called before the special grand jury before the election. And then after the midterm elections, Fani Willis said she will start calling witnesses again, and Lindsey Graham will be one of those witnesses who will be called. We also learned that prior to this quiet period today as well, Kelly Loeffler and Pat Cipollone were also given testimony to the special grand jury in Fulton County. That is likely how we also got Kelly Loeffler's text messages, which were likely produced in response to the grand jury subpoena, or the special grand jury subpoena out of Fulton County. We will keep you posted with more information here on the MeidasTouch Network. I'm Ben Meiselas. Make sure you hit the subscribe button now. We are on our way to 1 million subscribers thanks to your support. If you want to help join and help grow this movement, one way you can do that as well, in addition to subscribing, is check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch, patreon.com/MeidasTouch. There are a number of membership tiers there that you can join. But most importantly, I always get asked by you, how can we help grow this independent media channel? We're not funded by any outside investor, so our competition, which both sides the issues or promotes fascism, they're funded by billions of dollars. We have no outside funding at all. We're fueled by democracy. We're powered by you. And one way you can help grow this is by going to patreon.com/MeidasTouch and joining one of those membership tiers. It would go a long way to help. So please do that after this video. Until next time, I'm Ben Meiselas.
MeidasTouch is unapologetically pro-democracy. And look, we know you are too. So please make sure you check out our best-selling shirt and our best-selling gear, the unapologetically pro-democracy gear. And hey, while you're at it, make sure you check out my favorite shirt and one of our most famous designs. It wasn't rigged, you're just a loser. At store.MeidasTouch.com. That's store.MeidasTouch.com.